Hi, everybody, and welcome to Hell is for Children. This is a weekly show for and by protective mothers. So, what's a protective mother? A protective mother tries to protect her child or children from their abusive father by many means necessary. And that's an uphill battle in today's global corrupt family court system that thrives on paternal entitlement. And that's why it's my great honor to introduce to you today my guest, Barry Goldstein. And Barry worked as a domestic violence attorney for 30 years. And even though he is retired from the courtroom, he has not stopped fighting against domestic violence and child abuse. And we'll get into all he does for protective mothers and our kids on this show. And Barry is joining us today by phone. So welcome to Hell is for Children, Barry Goldstein.
I'm looking forward to participating today.
Hi. So I think I can speak on behalf of all the protective mothers out there when I thank you for all you do for protective mothers as a man and as an attorney. We all wish there were more men and definitely more attorneys who would stand up against domestic violence and child abuse, and not just through words, but through actions. And you lead the way in this regard as you have dedicated your life to fighting for battered and sexually abused women and children. And not only have you been an attorney representing victims of domestic violence for 30 years, you also co-authored the book Representing the Domestic Violence Survivor with author Elizabeth Liu. You co-edited Mohana's book, Domestic Violence, Abuse, and Child Custody. You also wrote two books yourself, one called Scared to Leave, Afraid to Stay, as well as The Quincy Solution, Stop Domestic Violence and Save $500 billion. And on top of that, you've also been an instructor and supervisor in a New York Model Batterer program since 1999. Plus, you provide workshops, judicial and other trainings regarding domestic violence, particularly related to custody issues. And you serve as a consultant and an expert witness. And you are the research director of the Stop Abuse campaign. Can I just say, wow, what an impressive amount of work you are doing on behalf of protective mothers and their children. So really wonderful. I kind of wanted to start the show by, stating, well, like I just said in the introduction, you are retired now. But can you share with the audience what your experience has been as a domestic violence attorney during the 30 years you practiced your profession?
One of the things that, as an attorney, you can't always predict how a case will come out, but you should be able to predict, there are certain parameters of possible outcomes depending on how the court views this. And one of the things I saw early on is we kept getting decisions that were totally outside reasonable parameters. They were not possible outcomes, and yet that's what the court was doing, and that was very concerning.
So can you say that you saw a pattern where abusive fathers were getting custody of their children regardless of evidence? Because in my case, I present a lot of evidence of child molestation, and this was expert evidence, and the court just disregarded any of that. And my ex admitted that he had an addiction to hard drugs, and they didn't seem to care much. So what's up with that?
Well, if you think about it, domestic violence really only became a public issue in the mid to late 1970s. And at that time, we had no research. And a lot of the popular assumptions that the courts based their approach on turned out to be wrong, but they haven't adjusted their practices to the new research, so that today we have a substantial body of research that would make it a lot easier for courts to recognize domestic violence and child abuse and come up with outcomes that would protect children. but they never got into the practice of applying this research. And one of the fundamental mistakes that they made in the 1970s that continues to today is that they thought domestic violence was caused by mental illness or substance abuse, and so they turned to mental health professionals who are experts in psychology, experts in mental illness. They're not experts in domestic violence. They're not experts in child sexual abuse. So what keeps happening is that they deny true reports of abuse. They don't know what to look for, and they focus on less important issues. And those are the ones who are trying to do the right thing. Then we have the cottage industry of lawyers and mental health professionals who found that they can make a lot of money by helping abusers, and the misinformation that they provide to the court not only hurts that case, but provides misinformation that the courts use in a lot of other cases.
Yeah, there seems to be a kind of a script going on in all the cases that I looked at, and I looked at thousands of cases where the mom will present evidence of a child molestation, for example, or will tell the court that she has been battered. And then the father will claim something called parental alienation syndrome, which is kind of junk science that was invented by Richard Gardner in the 1980s, claiming that these moms will just make up false allegations to alienate the child from the father, but in essence, that's the opposite is happening, because the research has shown that in most cases, actually, the mothers are not making false allegations, but that actually the fathers lie about what's happening in court. And so, but these judges, they love this script. As soon as we go forward and put this evidence out there, and the fathers claim parental alienation, the judges then award full custody to the fathers, to the abusers. And from what I understand, I kind of, would love to have your feedback on this, is you mentioned this cottage industry. It seems like one of the reasons why this is happening is because they know that mothers will never stop fighting for their children, so they keep on spending money on attorneys and evaluators and guardian ad litem's, and they never close these cases. They keep them ongoing. Am I on the right track with what I'm seeing?
Let me give some perspective, but let me start with PAS. It's not just that there's no research. It wasn't based on research. It was based on the personal beliefs and experiences and biases of Richard Gardner. And those included several public statements to the effect that sex between adults and children can be acceptable. Now, I doubt that any judge would want to be associated with such an obnoxious belief. The problem is, particularly at this, one of the things you also hear very frequently is the idea that children need both parents equally. And that's a lie. Children need their safe parent more than the abusive one. They need their primary attachment figure more than the other parent. And to treat parents that are of different importance to the children as if they were the same starts with a fundamental mistake that doesn't benefit children. And too often the courts are focusing on the rights of parents instead of the health and safety of children. And again, all of the mistakes that the courts are making err on the side of risking children, err on the side of helping abusers. And that's why such a high percentage of contested custody wind up with the abuser gaining custody.
So how come there are so few attorneys working on our behalf? I mean, I know there's attorneys working on our behalf, but once they claim that they want to help us, but then most cases they just bleed us dry financially without actually getting us the help we need. What can we do about this?
I have to laugh. Sometimes you'll hear abuser rights organizations promoting the idea that there's a domestic violence industry, and the implication is that those of us working to help victims of domestic violence are doing so to make money. And the opposite is true, and what they're really showing is what they're doing. The fact is that most of the money is on the side of abusers, so that if you want to make a decent income, taking the side of protective mothers, doesn't do it. You're going to get paid a lot less, and you're going to get an awful lot of mothers who have little or no resources, desperately needing your help. And when I was an attorney, very frequently, I would have clients that came to me after they were represented by another attorney who charged a lot more than I did, didn't know what they were doing, undermined the case, and then sent it to me when the mother had, almost no money left, and, the case was in a lot of trouble. And so the simple answer to your question is it doesn't pay to represent protective mothers. The benefit has to do with, helping children and doing the right thing rather than any kind of financial benefit.
Yeah, that kind of brings us to the whole father's rights funding. These father's rights groups have worked so hard in the last 30, 40 years. They have actually get federal funding, so it seems to be, with their fatherhood.gov, but there's no motherhood.gov or, children's rights.gov or anything like that. That actually creates an unequal playing field. Can you say something about that? What can we do to get these things equal?
I think one of the problems that we have is that to understand these issues, it's really complicated, and it takes a while to explain it if we're going to do it in an honest fashion. And the other side can just give simple, easy to understand explanations that are just totally wrong. So I started saying that because, there is some money, some significant money that, from the Violence Against Women's Act and, for domestic violence shelters and things like that. But one of the problems with that money is that it sort of encourages a professionalism as opposed to a social activism. And many of the domestic violence agencies are afraid to challenge people in authority who are hurting women and children. And so that also undermines the work that we're doing. Now, clearly we need to provide more funds to help battered women and their children. And one of the things I've tried to do with the Quincy solution is look at the economic side of things. When we understand the huge amount of money that is spent to allow men to abuse women, it means that when we spend money to prevent domestic violence, we're helping ourselves economically in addition to the human benefits.
Let's. What I'll do is I'll share my screen and bring up the Stop Abuse campaign website, and then we can look at that Quincy solution that you're mentioning. So let me share my screen here. We are at the Stop Abuse campaign website. You are the research director of the Stop Abuse campaign. For anyone who's interested, you can find the website here. And let's start with the Adverse Childhood Experiences Study. Can you tell us what that's about?
Yeah, I'd be happy to do that. I don't know if I should mention this or not, but on my screen, I'm not getting anything. I'm not getting the picture anymore. I'm not, it says there's some kind of technical problem, so I don't know if that's true for everyone, but I just wanted to mention that. In terms of ACE, it stands for Adverse Childhood Experiences, and it is really an exciting bit of medical research. It comes from the Centers for Disease Control and Prevention, so it's highly credible. The fundamental finding is that children exposed to domestic violence, child abuse, and other adverse childhood experiences will live shorter lives and suffer more illness and injury throughout their lives. And one of the important findings is that you don't need physical abuse in order to create all the harm that we're talking about. That fundamentally, if you think about domestic violence, it's various tactics that abusers use to scare and coerce their partner to do what he wants. And when you do that, obviously you engender fear in the mother and in the children. Living with that fear creates the worst kind of stress because you have no way to control it. He's not abusing the mother because of anything she said and done, but just based on his own beliefs, etc. So you can't stop him, other than, the law enforcement stopping him. So that creates the stress that leads to all the health problems that we're talking about. And, the problem is that for thousands of years, we've tolerated what we now call domestic violence, what we now call child abuse. And so that's baked into all of the statistics. But what is really exciting is that based on the ACE research, when you think of the present level of cancer and heart disease and diabetes and mental illness and crime and prostitution and dropping out of school and suicide and all sorts of social problems, if we can, which we can, reduce domestic violence and child abuse, we can reduce all of these horrible illnesses and social problems, and our life expectancy will go up significantly. And that's exciting, and it ought to provide an incentive to take domestic violence more seriously, because we can prevent it, and if we do, we're going to have just wonderful benefits for ourselves and our children.
I absolutely agree. And I think anyone with a common sense would agree with what you're saying. The idea is only how do we get from A to B, right? Or from A to Z, really, I should say, because there's many steps to take. Now, I know that you started the Stop Abuse campaign, which has which is pushing the Safe Child Act, which is something that you put together. Can you tell the audience what the Safe Child Act is about?
Yes, I can. I just want to be clear. The Stop Abuse campaign started long before me. A man by the name of Andrew Willis, who was a Madison Avenue ad executive making large sums of money, and he quit his job and decided to work full-time to try to save children because as a child he had been abused. And so, I get to work with Andrew and Melanie Blow and other people at the Stop Abuse campaign, and it's a wonderful experience. The Safe Child Act, one of the things we hope to do is change the discussion, because right now it's a discussion we're losing. And so the first thing that it does, which when we talk with legislators, they are surprised that that's not already the law. We would say that in all custody and visitation decisions, the health and safety of children must be the first priority. I mean, how can you argue with that? I mean, that seems obvious, but if we were to actually do that, it would change everything, because think about what it means health and safety is the first priority. Domestic violence is a health and safety issue because of the reasons we just talked about, that, the harm to children from experiencing domestic violence. Obviously, any direct child abuse would be the same. But even something like primary attachment, very frequently, I think you were talking about your case, the court makes a decision that takes the primary attachment figure out of the child's life. Now, we know that that causes an increased risk of depression, low self-esteem, and suicide when older.
Mm-hmm.
And that's a health and safety issue. On the other hand, the courts have been focusing, as you said, on parental alienation syndrome. Well, according to the ACE research, unless the alienation is so severe that it completely takes the other parent out of the child's life, that's not a health or safety issue. And in fact, it'll be resolved fairly quickly, unless it's an abuser using domestic violence by proxy. So that if we're focused on the health and safety of children, it creates a very different analysis. And the other part of it is that appellate courts will defer to trial judges because they have observed the demeanor of the witnesses. So that makes courts totally subjective. Whatever the court decides, there's no way to overcome it. Whereas if we say it has to be health and safety and they focus on issues that are less important, we can get it overturned, which means the Safe Child Act will provide accountability that is very much missing. The Safe Child Act also requires that the courts integrate important new research like the ACE research, which explains the impact of domestic violence on children, the Saunders study from the U.S. Justice Department, which demonstrates that today many judges, lawyers, and evaluators do not have the specific knowledge that they need, and that leads them to make decisions that hurt children. We also have a provision in the Safe Child Act for an early hearing, which would be limited to the issue of domestic violence or child abuse. So that what that means is all of the tricks that abusers use to distract attention are eliminated. The only issue is, did he commit domestic violence or child abuse? And if he did, we know the outcome. Safe mother gets custody. The abuser initially gets supervised visits. And what that means is cases that now take many months or years get resolved in an hour or two. And we don't need the expense of a GAL, and we don't need the expense of an evaluator, because if there's abuse, we know what the outcome is. We don't need to deal with all the other types of issues. And one other thing that the Safe Child Act does is it says that the courts should not be using unscientific theories such as ones that are based on the belief that sex between adults and children can be acceptable. So, we are excited about the Safe Child Act because we think that can totally change the court system. And if you think about it, what that is, it's evidence-based, it's based on the research, it's multidisciplinary, based on the Saunders study. It says use the expert that you need. Don't use a mental health professional for everything. use a mental health professional if you need help with mental illness or psychology. If it's child sexual abuse, use an expert in that. If it's substance abuse, use an expert in that. If it's domestic violence, an expert in that. If it's a medical issue, use a medical expert. This using a general practitioner for the equivalent of heart disease doesn't make sense, but that's what we've been doing for a long time. So the Safe Child Act is a comprehensive legislative proposal that will change all the bad things that we're going to be talking about on this show.
Mm-hmm. So the part of it that I'm still struggling with, because when I got to court, basically, like I said, I submitted actual evidence of the child abuse. So what you're saying is they will weigh the parental alienation syndrome heavier, even though it's a false allegation, over the actual expert evidence that I submitted. And the Safe Child Act is trying to reverse this. Am I going in the right direction with this?
The first thing is that what I said a minute ago is that courts are not allowed to consider unscientific theories based on the belief that sex between adults and children is acceptable.
Right.
What that means is they can't use PAS.
Right.
Period. That's the end of that part.
But then we still have these abusers. They're kind of they're usually narcissists, and often they're sociopaths that kind of groom the institutions, the courts, to believe that the mothers are just making this stuff up, and they even say that we bribe the experts to put these allegations on paper. So, I wanted to share a website that gets into that, how the fathers' rights movements, how they legally stalk us through the courts. And, they also do this by constantly filing motions. This is the website I was kind of wanted to share. Battered Mothers, a Human Rights Issue. The Fathers' Rights Movement, how to legally stalk, harass, and intimidate victims of domestic violence after a restraining order has been issued. This is the legal abuse that Karen Huffer also talks about. The mothers are constantly harassed through the courts. And I kind of want to bring this up, this one section over here where it says, overwhelmingly, men join these fathers' rights groups after a former intimate or spouse leaves them to escape physical abuse or files for divorce. These groups in reality are batterers' rights groups, and they very quickly learned that an educated public had no tolerance for their archaic views of a man's rights to dominate his spouse through domestic violence. Like a cancerous organism, these fathers' rights groups have networked through the internet and adapted by publicly identifying themselves with conservative Republicans and latching on to the coattails of the legitimate men's movement. Already accustomed to networking through the good old boy network in business, they began lobbying the State House and pulling elaborate publicity stunts to get media attention. So in other words, these abusers, they don't just groom the child for sexual abuse, but they also groom the courts. And this article that I'm pulling up over here, The Fine Art of Institutional Grooming, gets into that. There's one particular quote I want to read here. Why would a perpetrator go to such lengths to manipulate people other than their victims? Because when their victims, the victim's family and friends, and the public service networks intended to support their victims are groomed successfully, the investment of all of that hard work does not go to waste. The victims are then still available to continue to abuse. So how does the Safe Child Act going to prevent this particular type of grooming that these narcissists and these abusers are so good at?
Okay. One of the things we just touched on in terms of the Safe Child Act is the use of current research, one of which is the Saunders study. What the Saunders study found is that court professionals need very specific training, not just generalized training, which too often includes support for alienation theories. Saunders found that court professionals who do not have the specific training that they need tend to focus on the myth that women frequently make false reports, tend to focus on unscientific alienation theories, and tend to assume that if a mother is trying to keep a child from their father that they viewed as scary, that they're actually hurting the child. What Saunders found, therefore, is that when you get a professional who is focusing on those mistaken assumptions, that means that they're not qualified to handle the case and their recommendations should not be followed. And it further means that what Saunders says is that these assumptions lead to outcomes that hurt children. So we are preventing, with the Safe Child Act, a court from focusing on the common mistaken assumptions that the abuser rights groups promote. And I think one of the other things I wanted to say in terms of the fathers' rights groups, because I certainly agree with what you were saying, one of the other hats that I have, I am the co-chair of the Child Custody Task Force for the National Organization for Men Against Sexism, which is NOMAS. And one of the reasons I joined that is for exactly the reasons that you were talking about, that these abuser rights groups are trying to promote the idea that what's going on in family court is a dispute between men and women or mothers and fathers. In reality, it's a dispute between the vast majority of men and women who want children protected from abusers against a small group of extreme abusers who want to maintain control over their partners and are willing to hurt children to do that. And so to have a organization that is primarily male, like NOMAS, supporting protective mothers is really important because it corrects the record in terms of what this dispute is really about. And, so I think there are a lot of things within the Safe Child Act that will help reframe the issue. And, one of the things I experienced as an attorney is very often judges would say, if the legislature didn't like what we were doing, they would tell us. When the Safe Child Act passes, the legislature is telling the courts, stop doing what you're doing because you're hurting children.
Mm-hmm. Well, that sounds really good. It sounds really promising. I truly hope that it will work, that it will get passed. Can you tell us where we are with the Safe Child Act in terms of this bill?
Well, remember, it's fairly recent. A few months ago, for the first time, the first state introduced the Safe Child Act. That was Hawaii. And, I want to tell you that Andrew Willis and I are so dedicated to this movement that we're willing to go to Hawaii to help promote the Safe Child Act. Usually the junkets aren't quite that good. But the thing is, we have some promising developments in Hawaii. We have a meeting with a very influential judge that we will start, with when we get out there, and we're hoping to get it passed there. Also, fairly recently, the first draft of the Safe Child Act in Pennsylvania was prepared, and we're trying to get a few corrections, but we'll hopefully move on that. There are some other states that has started work in talking to people, but we still have a long ways to go. One of the things we have with the Stop Abuse campaign, there's um, an action group on Facebook, which we divide up into the different states to try to promote the Safe Child Act in each state. And so we would encourage anyone who's interested to get involved with the Stop Abuse campaign as we try to promote the Safe Child Act.
Yeah, it would be good if everyone gets on board with that. The more people who are on board with that, the better, as far as I'm concerned. One of the things that I was wondering, and that a lot of the moms are wondering is, what can we do? One of the things that right now in the United States is the case is that women don't have any constitutional rights. And a lot of women don't know this in America, but this is the case. And the protective mothers are finding out that, that there's not a lot they can do because they don't have any rights within the Constitution. Does the Safe Child Act also work on that particular issue?
I don't think that it's a constitutional issue. It's really more fact and research. I think the Safe Child Act is trying, as I said, to change a conversation, change the atmosphere in the courts, change the focus on the courts. One of the big problems in, I think, what you're concerned about in terms of constitutional rights is that family court and child custody are uniquely a state issue. And so there are federal court decisions that very much limit what federal courts can do, and also limit what administrations or Congress can do. I mean, there are things they can do on the outside, that can help, and some things they are doing that we can talk about, but they can't tell Missouri pass this law or do this. It's a state issue under federalism. What they can do is provide grants to encourage courts to do the better things, and what they can also do is research. So the Saunders study, which comes from the U.S. Justice Department, is really helpful for our cause, and it was something that they did to help us. I was involved in some roundtable discussions with OVW in the Justice Department, and they made findings that the present practices are working very poorly for battered women and their children, and they have provided technical grants to 4 state court systems to try to create reforms. And that's the things that they can do. And it's a lot harder to get reforms state by state, but that's what frankly, it's what the Constitution provides.
Well, the reason kind of why I asked it is because, as I'm in this nightmare with so many other thousands of moms, I'm starting to wonder, do these family courts really actually have the rights to make decisions about family life? I mean, here's a bunch of strangers making decisions about family life. Is that really what our forefathers, our American forefathers, intended? I highly doubt it.
Well, I mean, if you think about it, the original idea behind family courts was that you wanted courts that would specialize in children's issues so that they could take better care of children. The problem is that, as I said before, right now they don't have the specialized knowledge that they need, so they keep getting it wrong. Maybe we should address, what is really the elephant in the room, which is the issue of corruption. And I know that most protective mothers believe that the bad decisions are caused by corruption. And there's good reason for them to believe that, in the sense that the outrageous decisions, the unfair practices, really create the appearance of corruption. And there is corruption in terms of the cottage industry. And there's, individual cases. There was a case in Brooklyn where a judge took bribes. But I think that's more the exception. When, as I said, this issue is more complicated. And the thing about it is that I believe it's ignorance, it's bias, it's, doing the usual things. It's the unfair economic advantage that abusers have. I think it's issues like that that are mostly responsible for the horrific outcomes that we see.
I'm sure you're familiar with the work by Phyllis Chesler. And I know that, I would like to focus on the abusive fathers who have gotten custody, and she has concluded from her academic research that 82% of abusive fathers get full custody. So it's hard for me to kind of go into your ideas around this by thinking that that would not have anything to do with corruption. So what you're saying is that the judges are not educated enough, or attorneys or people involved are not educated enough to make decisions, to make the correct decisions for children, but that's the academic research already shows that these abusive fathers, that 82% of them get full custody, and in most cases the moms have supervised visitation or no contact at all. If the mothers speak up about their cases, they get retaliated against. They are put in jail. They're often also ordered child support. So here we are going from being primary caregivers to suddenly getting jailed because we can't even pay the child support to our court-adopted children. That doesn't seem to me like an education issue. The cases are so clear that it'd be hard to give any other explanation than corruption for that, and paternal entitlement, of course, as well.
I certainly understand why you're saying that, because it certainly looks that way. And, one of the fundamental problems here is this myth that women frequently make false reports. And, we've had situations where it's been revealed that judges were taught to disbelieve mothers' reports. And I think that helps to explain what's going on. The study referred to by the Saunders study, which is the Bala study, confirmed that deliberate false reports by mothers occur less than 2% of the time. And the problem is that the judges and the lawyers and the evaluators mostly believe that it's very common for mothers to make false reports, so they're focused on that. There have been 40 states with gender bias committees appointed by the courts, have all found widespread gender bias, and they haven't corrected it. You have the courts relying on evaluators who don't understand domestic violence. They don't know what to look for, and so when they fail to find it, then they're assuming the mother is making deliberate false reports. And as you said, they retaliate against the mothers. So much of the bad decisions, the bad approaches are based on fundamental misconceptions. Remember that for over a generation, the courts have heard the misinformation constantly, and neutral professionals are repeating the misinformation. That's why we have to change that. One of the things I particularly like about the Safe Child Act, it changes the discussion, and it says to the judges and to the courts that what you're doing now is not working. It's hurting children. We need to do something differently. Don't go back and do the same things again.
But isn't it obvious that the children are hurt? Like in my particular case, I had a hearing in December of last year and in January of this year, and I explained to the judge that the father is not allowing any contact, while there should be contact several times a week. And the judge just doesn't, place any consequences on that whatsoever. I mean, you take any normal person can conclude that it's not good for a child, first of all, to be taken away from the primary caregiver and then taken to another country and then not be allowed any contact. It's breaking the court orders, so why would a judge not place any consequences on that then?
One of the fundamental problems that we talked about a little earlier was that there is this bias. They're concerned that fathers will be removed from children's lives. They're not afraid that mothers will be, because they see the mother's relationship as much closer, so that they don't focus on that. And it's one of the biases that we see. And they've been doing this for such a long time, and they're not getting reversed, and they're not getting any kind of negative feedback. If you think about it, the only thing that judges really fear would be to be on the front page of a newspaper. We've had all too many cases where the court gives the father access and he uses it to kill the children. But most of the time, the harm to the children isn't that dramatic. And since the murders are usually in different communities, they don't see the pattern. And so they don't understand what's going on. They don't understand the harm that they're doing. And frankly, they don't want to. They are very defensive. When they are criticized, they retaliate. They try to silence critics. And, they don't want to take a new look at what they did, even when there are murders in their community.
Yeah. Well, that's what's hard for me to understand, and I think most of the mothers who are watching the program right now, we're flabbergasted, because these are just gross human rights violations, and just because a judge doesn't want to go back on their decision, those judges should be removed. In fact, what I believe, and since I've been looking at all of this and researching this because of my own nightmare, to me, it seems like the best solution would be to have all these child abuse cases handled in criminal court. Because really, when you abuse a child and you have expert evidence of abuse, then it's no longer a family court issue. What are your thoughts on that?
There is a wonderful chapter in my newest book with Dr. Hannah, written by Camille Cooper. And what she looked at is how we respond to child sexual abuse cases. And what she found is that when the alleged offender is a stranger, it is investigated by law enforcement. It's done aggressively. They quickly try to interview the suspect. They try to get him to take a lie detector test. They're gathering evidence, and the purpose is to bring criminal charges. But when the alleged offender is someone that the child knows, particularly a close relative, which is what we're dealing with in family court cases, the investigation is led by a social worker. They give the parents notice so that say the offender is a father, he has time to silence the child and destroy evidence. The purpose is not to gather evidence, because what they're trying to do is reconciliation. And if the case later gets to family court, the lack of evidence is treated as if it's proof that the allegations were deliberately false. And the result is that in custody cases, when there are reports of child sexual abuse, 85% of the time, the alleged offender gets custody, even though less than 2% of the reports are deliberately false. Now, part of it is that child sexual abuse is hard to prove. But overwhelmingly, court professionals don't want to hear about child sexual abuse. They focus on alienation. They have a hard time believing that someone who is successful in other parts of their lives could do something so horrible. And so we have a whole system that is a failure. And it's even bigger than that. One of the findings in the ACE study is that basically in the United States, 25% of our children will be sexually assaulted by the time they are 18. That is outrageous.
Yeah.
To tolerate that is horrible. We should be moving heaven and earth to prevent that. And what was interesting about the ACE study is it was done in a way that eliminated any possibility of false reports. So we know that a quarter of our children are being molested or raped, and we haven't been doing something. I think there are probably psychological reasons. It's really hard to deal with something like that, but we really have to. And of course, the custody courts have been particularly bad about this. Child protective agencies have been particularly bad about this, and this needs to be changed.
Yeah, like I said, to me, when there's evidence that a child has been sexually molested, it's a crime, and the people inflicting these crimes should just go to jail. I mean, and I think anyone with a normal thinking person would think that that's the way it goes down, but it doesn't. It's just bringing me to the point where you're saying that it's easy to actually find out who those 2% of mothers are who are actually bringing in false allegations. Can you tell us how that's done? Is that some kind of a lie detector test or some kind of psychiatric evaluation, or how do they find out who these 2% are that are lying?
I'm not sure. I'm saying that it's easy. I'm saying that it's rare, and the problem is that the courts are starting their investigation assuming that these are false reports.
Yeah.
And one of the things I've written in some of my articles and chapters that I think is really important, think about when there is a report of child sexual abuse. And remember that it's different than domestic violence. If a mother says, there's domestic violence, she has personal knowledge. Most of the time when we're dealing with child sexual abuse, there isn't personal knowledge for obvious reasons. The father's not going to do it in front of anybody. So when there is a report, the most likely explanation is that the child was sexually abused. Another possibility is that there was a boundary violation but not direct abuse. Another possibility is that we don't have, sufficient evidence to determine what happened. Another possibility is that it was a good faith report or a good faith request for an investigation, but in fact there was no child abuse. The least likely explanation is that the mother is making a deliberate false report, but that's what the courts are focusing on.
Yeah,
and they've been doing this for a very long time.
So what you're saying is like they're always focusing on the fact that most mothers are, what they're saying is that mothers are always making up these claims. Well, it's in fact only 2%, but they use this anyway. And to me, most of these things, and I know because I researched this, things like narcissism, sociopathy, and pedophilia can be scanned by MRI brain scans. And that's why I'm thinking like these are the types of testing that's currently not happening within family courts, but would be happening in a criminal court proceeding. What are your thoughts on that?
I'm not familiar with that research, and I would really doubt it because domestic violence and most child abuse is not caused by mental illness. If we had a simple test like that, the criminal courts would do a lot better in terms of child sexual abuse. I think we need to change how we investigate child sexual abuse. We need to take it much more seriously. And one of the things that I've said a number of times is, if you think about it, in the last couple of years, there has been a major focus in this country in finally dealing with rape on college campuses, with sexual abuse in the military, and those investigations and those policy changes were long overdue. But how can we allow a quarter of our children to be sexually abused, and that's not a priority?
Right, I totally agree with you. Yeah, there are such tests. There are tests, and I've talked to a forensic expert who talked to me about tests that can be performed on suspected pedophiles. And this is kind of where I would like to see the direction going. To me personally, like I said, I would like to see these cases handled in criminal courts, because they are crimes against children. A lie detector test, I know they're not reliable, but, there should be more development in that direction. And then, in conjunction with MRI brain scans, such as scans for narcissism and sociopathy. And of course, any kind of investigation that's been done with the child. And obviously that it brings us kind of to the CPS discussion, because where is CPS in all of this is the great question. That's another elephant in the room, so to speak. They should be handling these cases. When my daughter was deported, I sent CPS in Marin County, California, all the reports about my case. There were a total of 6 reports, plus a report from the United States, so 6 Dutch reports, and 1 from a therapist in Austin, Texas. And they disregarded all of these reports. So what can you say about that? Why isn't CPS doing anything?
Well, child protective agencies have done a particularly poor job, particularly on child sexual abuse. I think, they have the same mistaken training that a lot of court officials do. One of the things we should be doing is sending young children, particularly for play therapy, because what that does, it allows the child to reveal whatever he or she needs to reveal without realizing that they're revealing it. So it takes the issue of false reports off the table, and that would be helpful. We also need to safeguard keep the child feeling safe. If you allow the abuser to have access to the child during the investigation, that may silence the child. And at the same time, I've seen some agencies separate the child from the mother, and the child views that as a punishment, and it pressures the child to recant. And of course, it's very common for true reports to be recanted, but in family court, they don't realize that. I think we need to change how we respond to child sexual abuse, and we need to be much more open to the likelihood that, most of these cases are true. Now, a defendant has the right to be defended, and it has to be proven, to a high degree. But, one of the things I find is that if we don't convict somebody of domestic violence, of child sexual abuse, that doesn't mean they didn't do it. It means they can't prove it beyond a reasonable doubt. That doesn't mean that we should treat it as if it's a false report, much less a deliberate false report. But that's, one of the many mistakes that court professionals routinely make.
Yeah, that's a problem, because then law enforcement that's supposed to do mandatory welfare checks, for example, they just look at these court orders and say, well, the judges decided that nothing's going on, so we're not going to do anything. So it trickles down to, schools that are involved, society that's involved, family and friends that are involved. They say, well, the father's got full custody, so there must be something wrong with the mother.
Right. I mean, most people don't know that the courts make mistakes an awful lot of the time with contested custody. And another big problem there is that there's a lot of particularly child protective agencies that assume if an issue comes up when there's a custody dispute that they don't investigate the report because they think it's related to child custody. And then when you get to the child custody court, the lack of a finding is treated as if it was proof that it's a false report. So, I mean, there's a lot of just standard flawed practices that have been used for a very long period of time.
Yeah, that's exactly what happened in my case. The judge basically said, well, CPS hasn't, they've done 2 home visits and they didn't find any molestation. It's like, well, molestation is not going to happen in front of a CPS worker. And like you said, that happens behind closed doors when no one's around. So, as far as I'm concerned, the CPS needs to be abolished or completely overhauled because they are not doing anything to protect the child. They're doing the opposite. They're not doing anything, and therefore the children are placed with the abusers. And so I call them child abuse services. And this kind of gets into hand in hand with the entire how the entire system operates, right? Because these fathers, they figured this out with this fathers' rights movements, and now we know that, like you mentioned, the cottage industry, a lot of court professionals set their own outrageous hourly fees, and this has become, the kids for cash scheme. I see it as a the biggest Ponzi scheme, dirty little secret of American society that we're trying to out, like right here on this show. And so, in my opinion, human rights and financial incentives just don't mix. And we need to take the financial incentive out. That whole cottage industry, that needs to stop. And one of the ideas that I have around that is to start a mandatory custody insurance program that for all divorcing parents to be enrolled in, through which then all these court-involved professionals should be paid an equal hourly normal government wage. This is just kind of my thoughts. What's your thought on that idea?
Well, I mean, if you had insurance like that, it would probably encourage more litigation, which is not what we need. I have looked at and I have thought about the idea of having court employees who do the evaluations, and the same could be true for some other things, and that way they wouldn't have a financial incentive to favor the wealthier parent. Another really important part of this, though, is that courts need to make orders that allow both parents to afford the expertise that they need, and particularly lawyers. Because as we said before, domestic violence is about control, including financial control, and the courts need to level the ground so that if the father is controlling all the money, it shouldn't be that he has an attorney and the mother either has a less experienced attorney or loses her attorney because she can't afford it, and the father uses a lot of tactics to make it more expensive in order to gain an unfair advantage. The courts really need to pay more attention to balancing the legal and other resources that both parties have, especially since it's coming from the same family.
Like in criminal court, if you don't have money to afford an attorney, then an attorney gets appointed to you. Not that I'm saying that that would be the perfect solution for a family court issue, but that something like that should be in place. Because right now, most of the most of the protective mothers that I see in my network, they're all in, self-litigating, self-represented litigants in court, which is completely unfair. Because now, the mothers have lost their children, and now suddenly they spent their days in law libraries trying to figure out how to present themselves, while they're completely traumatized with the grief of the loss of their children. It's completely unfair.
Right. And the thing is, presenting evidence is a very technical issue. There are other, if you're going to argue, should you have temporary custody or something, an intelligent mother, can do that. But, lots of times there are technical evidentiary rules that only an attorney would understand. And, evidence that the court needs to consider doesn't get in. And that's bad for courts, because courts can't make the right decision if they don't have all the information. And there may be technical reasons that seem totally unfair, but those are what the rules are. But, courts have the authority to order the wealthier parent to provide resources, and especially in a DV case, they should be doing that. And so that needs to change in terms of their practice.
Mm-hmm. And another thing that I was thinking about is when a parent, and it's usually the fathers, the abusive fathers, use the courts as a form of coercive control over women, over the mothers, that should become a punishable act. Don't you agree?
Well, what I would like the courts to do is to look at the pattern of abuse. And, very often courts are only thinking about physical abuse, but most domestic violence is neither physical nor illegal. So they need to look at psychological abuse and verbal abuse. They need to look at monitoring behaviors and isolating behaviors. And one of the things they need to look at is litigation abuse. And, too often the courts are thinking, well, in any case, each party tries to maximize their advantage. But there are abuser tactics that are very harmful. And if the court did nothing more than notice how an abuser is using these tactics and use it against him to help understand his motives, it would stop, because it would no longer benefit the abuser to do it.
But then what you're suggesting is that we need to make psychologists out of all of these judges.
No, what I'm suggesting is we have to retrain them. And a good part of the training needs to be done by domestic violence advocates.
No. Now, what do you think about the idea of jury trials?
That's been suggested, and I think Texas is one state that has that. Unfortunately, it will tend to help abusers because they have more money. And when you have a jury trial, you have to be even more strict about evidentiary and other rules. So a jury trial is going to benefit abusers. It sounds good in, theory, but in practice, it's going to work in the wrong direction.
It actually helped a friend of mine who was also Dutch, and her abusive ex got full custody of her two daughters in Texas. She didn't see her kids for 2 years, just about, except for the occasional visit here and there that he would allow. But eventually the case went to court in Texas, in Harris County, and her ex had requested a jury trial. And during the jury trial, there were two other witnesses that she had on the stand, which were his new girlfriends or ex-girlfriends, who, showed that a pattern of abuse. what had happened to her had also happened to them. And so there was that pattern was enough for the jury to then say, this man is showing a pattern of coercive control and abuse, and not just with her, but with these other girlfriends too. And they awarded full custody of the children to her, and she was actually allowed to take them back to the Netherlands. So I have seen it work. I think to me, and this is interesting too, because the judge in that case told her afterwards that it would have never happened had he been ruling in the case. It only happens because it was a jury trial.
Right. I think it's a mistake to try to make broad ideas from an individual case. In general, jury trials, are dangerous for protective mothers if they don't have the resources that the abusers have. Obviously in an individual case, anything is possible. But if you look at patterns, which we should be doing more of, I don't think it's a good idea.
I think it would probably only work if if we had all the other points that we just discussed in place, where the mother and the father would both have, an attorney. Obviously, I don't think a protective mother should ever be in court unrepresented. It's illegal in Europe. It's illegal to be in court without an attorney. If you don't have the money, you get one appointed to you. And it should be like that in the United States as well, as far as I'm concerned. So those were kind of the solutions that I had, my four-prong approach, that family court should be abolished, and crimes against mothers and children should be handled in criminal court. Then there's, the moms that say we need to get the Equal Rights Amendment passed. Let's talk about that. The Equal Rights Amendment, if that is passed, how can it benefit protected mothers and their children, of course?
I certainly would support the Equal Rights Amendment. Obviously, it came very close once. But, the problem is that there are some very conservative states that would be unlikely to pass something like that. So, I think it would be a good idea, but I think it may be unrealistic right now.
But let's say we were able to get enough support around this and really rally around this topic and get it passed. How could it benefit us in court? Would it be beneficial on a federal level, for example, in federal court?
As I said, you're not going to be in federal court, because of federalism. But one of the things it would give you a strong argument in terms of the court bias against women that you're dealing with now. One of the things I've noticed that is interesting, I've written a little bit about it, is that when a court figures out that a father is dangerous and limits him to supervised visitation, there's immediately a tremendous urgency to get him to be able to have normal visitation with the child. But when a mother is prevented from having normal visitation, which is usually an alienation type claim that has nothing to do with the health and safety of children and is really based on flawed practices, but we know the mother is safe, there's no danger for the children in being with the mother, the courts are willing to allow that to go on for years or forever. It's one of the many examples of bias of how we treat men and women differently. And I would think with an Equal Rights Amendment, you would be in a much stronger position to complain about the kind of bias that women experience every day in the courts.
Yeah, and that's why I appreciate it so very much that that you and Andrew Willis and the other members of the Stop Abuse campaign, that there's men in the Stop Abuse campaign organization. We need men society-wide to start participating in this, because when women and children are not safe, it affects everybody, and it affects generations to come. The impact impact on humanity is just enormous. And I see this whole effort for the LGBT community. That's wonderful. But now we need to get the effort around the safety of women and children, for crying out loud. So I applaud all the efforts that you're putting forward. For now, since the Safe Child Act has not been passed yet, and we discussed that a lot of the protected mothers are in court without representation, in what we call pro se status. Let's discuss some things that the moms could do possibly. What I want to do is share my screen here. Let's see. And discuss some options for protective mothers when they are in court. So what I have here in front of me are torts arising out of interference with custody and visitation. There are various different types of torts from what I understand. Tortious interference with parental rights, intentional infliction of emotional distress. These are options, I would think, for pro se moms. Interference with visitation. I know that, for example, in my particular case, the father of my daughter has not allowed any contact since May 2015, and that's actually becoming a criminal matter now. I'm not able to be pro se from the Netherlands because the United States is not even willing to send me the court files, which is a whole other a can of worms that I don't want to open up. But for those protective mothers in the United States, would you recommend such torts for them to try?
I mean, I'm fine with using any responses that might work. I mean, I think it's hard to prove everything, to get a tort passed, and the issue is collecting. But I think there's another issue here that would be more used to protect the mothers who are listening in a situation like you're describing, where the father was given custody and now the mother has no contact with the child, or it's very limited. And that is within the Saunders study. There is a section that Saunders calls harmful outcome cases. And these are cases in which the alleged abuser is given custody, and a safe mother who is the primary attachment figure, which means that she did most of the child care for the first 2 years of the child's life, is limited to supervised or no visitation. And these cases are always wrong. And they're always wrong because the harm of separating a child, denying a child a normal relationship with their primary attachment figure is greater than any benefit the court thought it was providing. And these cases are based on the use of very flawed practices. Now, what this research means is that a protective mother can go back into court and ask for a modification because a U.S. Department of Justice study is saying that the decision the court made is certainly wrong.
I'm on your website and I'm showing these the Saunders study part 1 and part 2. Is that what you're referring to?
Yes. On my website, I have 2 articles that are about how protective mothers can use the Saunders study to help their case. And there are a lot of different things within the Saunders study that are helpful, but for mothers who are denied a normal relationship with their child, the harmful outcomes section, in my way of thinking, is really powerful, because, it's not often that you can go into court and say that based on a U.S. Justice Department study, the decision in this case is unquestionably wrong, and so the only issue ought to be, how do we correct it? And I'm not telling you that every judge is going to say, oops, sorry, let me help you. But this is a really compelling argument.
Yeah, that's the problem, right? Once the judge has made a decision, they often don't want to go back on their own decision. And is this something you also find with mothers who take their cases to the Supreme Court?
I mean, you have to follow the proceedings, and as I said, the federal government usually will not, or the federal courts usually will not consider these cases, with extremely rare exceptions. But what I would encourage mothers to do, you need to be able to present this information in a way the judge can hear. So I would emphasize, when the court made this decision, they weren't aware of the Saunders study. They didn't know that this kind of extreme outcome is always wrong. But now that the court has this information, we would ask the court to reconsider, and certainly we would hope the court would not want to repeat what is an unquestionable mistake.
Mm-hmm.
I mean, you have to figure out ways to say these things so that the court can hear it, because if you go in and say, Judge, you're an idiot, you made a decision that's always wrong, they're not going to respond very good. So you have to, find a way to say it in a way that the judge can hear. And certainly I understand, there are judges that it wouldn't matter what you said. But the thing is, if you say it in a good way and you're citing it like that, it may be a good way to get an appeal.
Yeah.
Because that's really a legal decision more than a factual decision. There's no fact, as long as, the mother's not having normal contact with the child and she is the primary attachment figure, and there isn't anything they can say that demonstrates that she's a danger to the child, it's not a factual issue. It's that the court is doing something that is always wrong. And, that's the kind of thing that an appellate court can reverse.
Well, but just explain this to me, because I'm not American, and I'm not a lawyer. So appellate court, that would be an appeals case from a family court case, yes?
Right. You would appeal to a higher state court.
Yeah. You have to do that
when you're doing an appeal,
mm-hmm.
with rare exceptions, you need to show that there's a legal error.
Right.
If you say, well, I disagree with the judge, I think the facts show something different, you're probably not going to get it reversed. But when you can say, there's no dispute, this is a harmful outcome case, it's always wrong, but the judge won't correct the error, so I'm asking the appellate court to correct it.
Well, you have to do that within 30 days after a court order, is that correct?
But what I'm suggesting here, I'm looking at a case where the court has made a bad decision, the mother is not getting a normal relationship with the child. You make a new motion asking the court to modify at least the visitation part, because the existing order is wrong. Mm-hmm. And if the court then says no, you have 30 days to appeal that new decision.
All right. Let's go back to the share screen, because there were a couple of other sites that I pulled up with things that we could be doing. Here are some motions according to U.S. Code 12203, prohibition against retaliation and coercion. I kind of wanted to pull that up. This is shared by Protective Mothers with me, we all try to help each other in these Facebook groups. So I kind of wanted to share this in case you're being retaliated against. There are some remedies and procedures over here. And I know that a lot of the mothers are now talking about the Americans with Disabilities Act. The fact is that when these abusive fathers take us to court over and over again, that's considered legal abuse. That is an actual term. That's an actual official abuse term for which we should be getting pro bono attorneys through the Americans with Disabilities Act. Is that correct?
Well, let me try to say it perhaps a little clearer. Under the Americans with Disabilities Act, if there is a circumstance that puts the mother at a disadvantage because of a disability, she can ask the court for a reasonable accommodation. And what's exciting about using the ADA is that it's a civil rights statute, so that if a judge fails to honor the ADA, he or she can lose their immunity, which means that they can be personally sued. And, one of the big problems with the custody courts is that there is so little accountability for judges. So to create a situation where the judge could risk their immunity would really make a difference. Typically, or one of the common situations in family court is PTSD. Where the father's abuse caused the mother to suffer PTSD, and you would have to get a doctor to certify that you have PTSD, and then you write a letter to the judge, and you might be able to do it in a motion, but either way, you're asking the judge for a reasonable accommodation, and you can make suggestions about what that reasonable accommodation would be. That doesn't mean that the judge has to rule for you and everything, but they can do things like say the father is pro se and he wants to cross-examine you, and he goes in your face and like that, and you could say, make him stay away from me. That would be a reasonable accommodation. If you need a break periodically, that would be a reasonable accommodation. If you need an advocate with you in court, that would certainly be a reasonable accommodation. There may be others. You need to, it's got to be related to the disability. But that certainly is a useful tool.
PTSD can also be used against the mothers, though, because the fathers can then say, well, see, she has a psychological problem now, and therefore she's an unfit mother.
I have a very different take on that, and I understand what you've said, because many people say that, and I think courts might say that if they were not challenged on it. The first thing is that mothers with PTSD can be wonderful parents, so it doesn't make her unfit. What it does make is the father unfit, because think about, in comparison to PTSD, think about a panic attack. Someone could suffer a panic attack for benign reasons. For instance, someone who's afraid to speak in public, if they had to do that, they might have a panic attack. That doesn't mean anyone did anything bad. But PTSD can only be caused from one extremely traumatic event or a group of traumatic events, which is usually what it is with domestic violence. It has to be really severe. What that means is, with all the evidence going back and forth, did he abuse the mother? Was it that bad? PTSD is the end of that discussion. If she has PTSD, we know that the father's abuse of the mother was horrific and that it's going to be harmful to the children. So if a mother has PTSD as a result of the behavior of the father, that means the father's unfit, and he probably shouldn't have anything but supervised visits. And it's really powerful evidence, because I don't know how you overcome it unless you can, you can try to challenge the doctor's diagnosis, but the father saying I don't agree with the doctor isn't going to be very helpful, because how can he know how his behavior has impacted the mother?
Right.
So that's going to be really powerful evidence.
Now, just to tag on to this from my own particular case, I'll take a minute out of these 2 hours to ask you a question about my case, because I'm not in the United States and I'm not an American citizen. My permanent resident card is expired, so I can't come back. Then I probably can't use this particular Americans with Disabilities Act, correct?
Well, I mean, I think it would be hard to prove things without being able to testify.
I could testify over the phone.
Well, then you can do it. I mean, it's up to the court rules, but, that's the issue.
So I could still use this particular act, even though I'm not American?
Yeah, I mean, aside from anything else, I think it would justify, it would really support the idea of doing it by phone. If the court says, well, we don't really usually do that, the fact that you have PTSD might be an additional argument.
Well, that's not really the question that I have.
I understand. I understand that, but I guess the point that I want to make is that doing it by phone would be a reasonable accommodation.
Well, they have done it. They've allowed me to do it over the phone. My point is more that it seems to be an act that's only for Americans.
I don't know the answer to that.
Okay. Yeah, because I know a lot of other mothers here in Europe who have lost custody of their children to American fathers. They seem to be, particularly abusive, the American fathers. Something in the culture over there, apparently. I will check that out though, because if that could work for me, because one of my questions with that is once we use this particular act, can we get pro bono representation through this Americans with Disabilities Act?
I don't think that follows automatically. I haven't seen case law or individual cases. I mean, I could imagine an argument that because you have PTSD, it would be really hard to go pro se, so you need the appointment of an attorney. And then I think the issue might become, is that a reasonable accommodation? And it might depend on what resources the court would have to provide that. And I think that would vary, by court.
So there's resources available. Those are not state organized. Those are not state mandated, or how does that work?
It varies. I mean, I think that there are some courts that might have the ability to request attorneys to represent somebody. There are some bar associations that require, attorneys to do a certain number of pro bono cases, and there might be some way to organize that, or there might be, other methods of doing it in some courts, and in other courts they may not have access to any possible attorney. I don't know the answer to that, but what I'm saying is it might vary depending on the individual court.
I think we need to research this more, and this might be a way for us to hopefully to get pro bono attorneys. I know there's a lot of the mothers, when I talk about this particular topic, they say we don't want any attorneys. The attorneys mess it up for us. We know our own cases better than they do. I don't know. There's something to be said about that. I know that the attorneys that have represented me, I've only had one good attorney. She really, really tried. She had a really good heart. She has a really good heart and real good intentions. Unfortunately, some of the other attorneys seem to me more concerned about the good old boy network that they were in. One of them actually told me, I can't say the things that you want me to say because I have to face this judge again in another case next week. And if I really go to bat for you, then I'm going to lose the case next week.
Right. I mean, that's a big problem. It's really that attorney was saying was unethical because you're required to advocate as best you can for each client, and to undermine one client's case in order to help another client is a fundamental conflict of interest that is ethically improper.
Right, but what should I have done at that point? Just fire him? I don't know.
Well, I mean, I would certainly say, you have an obligation to zealously represent me. You're saying that you can't do that, and what I'm telling you is that I need an attorney who is going to zealously represent me and present the information that I want presented, and then, he might withdraw, in which case you should be entitled to another attorney because it's not your fault if your attorney withdraws. Or he can decide, well, I'm going to have to find a way to uphold my ethical obligations.
Yeah, you got to come up with another $20,000 retainer at that point. That's a problem.
That's exactly the problem. And, in my book with Elizabeth Liu, we have a whole chapter about legal ethics, because I think there's a lot of, what you describe is all too common, and the legal community is not thinking about that fundamental conflict of interest. And, we do see a lot of cases where attorneys are afraid to present domestic violence and especially child sexual abuse evidence. And, in fairness to the judges, if they don't get this information, they don't even know the risks to the child. And I think that means the courts really need to consciously work to make it safe, to feel safe for attorneys and litigants to present information that now seems like they don't want to hear.
Yeah, exactly. All right, let me go back to sharing the screen here because I wanted to bring up one more site here. Let's see, this one, I believe. No. Okay, over here, justice.gov, submit a complaint. You can file complaints against the Department of Justice employees under discrimination. And here's the Americans with Disabilities Act. So if that doesn't get awarded to you, you can file a complaint. Then there's also the civil rights that you mentioned. Here's a complaint you can file about violations of civil rights. And I hope this is, you can also report fraud and abuse. I recommend for all the protective mothers to file these complaints. It's just massively bombard the Department of Justice with our cases this way. At least they will be heard. Although someone told me, and I saw an article about this, about the fact that a lot of these offices, when you call them, you get just an automated voicemail and emails. When you send emails to the Department of Justice, these are unmanned stations. No one's home. Have you heard about this?
I'll tell you something. Within the present administration, I have found the Department of Justice, and particularly the Office of Violence Against Women, to be extremely helpful. They get it. They know that the custody court system is not working right, and they're doing what they can to help protect the mothers, and they've done a lot of things that have been helpful. And I think I mentioned to you that they invited me to participate in a couple of roundtable discussions, and they've done a number of really good things. The problem is that their authority over state courts is very limited, and that's the problem. But what they have done, I think, has been very helpful, and I very much appreciate OVW, in the last 8 years.
So when you sent them an email, you actually get a reply?
Yes, but keep in mind, I'm sending emails to people that I've interacted with.
Yeah, because that's been one of my problems. I actually called the Fairfax Police Department in Marin County last week because an organization had told me that they had done some research about my daughter, and my daughter was supposedly deceased. I still don't know if that's true. I called the police department, and the Sergeant Crone from the Fairfax Police Department stated on the phone to me that he wasn't willing to do a mandatory welfare check. At the end of the conversation, I told him that I had recorded the conversation. He didn't like that at all, but I forwarded it to the Department of Justice because I need help with this. Law enforcement is not doing what they're supposed to be doing. What can I do to actually get that recording to be heard by a Department of Justice official?
Well, the first thing, that's a horrible situation for you to be in. I really feel bad about that. Have you tried to reach out to the California Protective Parents Association?
Yes, I have reached out to over 150 individuals and about 50 organizations. Most don't respond. If they respond, they tell me that my case is typical. There are hundreds of thousands of other mothers, and I'm just another case, and they don't know what to do. And they send, some of them send a reply.
I'm talking about a specific organization because the problem is Marin County is one of the most notorious counties in California in terms of the way the family courts operate. But I've had many protective mothers who have been helped by the California Protective Parents Association, which is why I mentioned them.
Mm-hmm.
And I know that they've worked in cases involving Marin County. So you might go back and look at that. They might have some contacts, and they might have a better idea.
Yeah, I will do that. Yeah, in my particular case, my ex-husband had moved the case from Nevada County Court, which is a county in California, Northern California. And he had moved the case without notifying me, and while he is the respondent. So the entire move is unlawful, and I mentioned that to the judge in the hearing. And as far as I understand, she should have recused herself at that point because I clearly stated that, she did not have any jurisdiction in the case. She refused to recuse herself, though. What are the consequences?
That's the wrong term.
Okay.
Recusing yourself is when you have a conflict of interest or something like that. What you're talking about is that the court did not have jurisdiction.
Right.
It's a different issue.
So when I mentioned that, at that point she said, well, you can't just mention that on the fly during a custody hearing. I don't know.
Well, that's wrong. If a court doesn't have jurisdiction, they never have jurisdiction, and it can be mentioned at any time.
And at that point, she should have stopped the case, I would think. Yes.
Well, I mean, it seems to me there's a factual issue that she might need to investigate, but
Right.
Certainly she needs to take that seriously.
Yeah, because that makes all the orders void.
Right.
the way I understand it, right?
Right, and it probably would mean that you could make a motion to dismiss everything that was done when there was no jurisdiction.
Yeah. Motion to dismiss. I'm writing it down. Sounds awesome to me. All right, let's go back to sharing the screen because I don't want this interview to be about my case. But what I got in front of me right now is the bombshell about the fact that these government offices are vacant. This is one of my big problems. Calling from the Netherlands, emailing, I barely get any replies. That's a real issue. So I'm not quite sure what can be done about this. I feel like I'm screaming in the desert and it's not getting me anywhere. And how do I get to actually talk to a real person? I think we're all kind of up against that. A lot of the protective mothers will CC me on emails that they send to the Department of Justice and there's just no reply. It's like no one home. I feel like we're in the Wizard of Oz and, as we all know, the wizard turns out to be, there's no one home. There's no one there. It's all a hoax. I don't know.
Well, I mean, the problem is, as we've talked about, that the U.S. Justice Department has very little power or oversight on these issues. And, I don't know the details, but, it may well be that, the wrong person is being called or, there's, some problem in terms of, who was sent to. I mean, I obviously don't know any of the details, but I can tell you that when I've reached out, they've been very helpful and very accommodating.
Okay. I want to share one last screen because we're about out of time. This is the one that I also wanted to share with all the protective mothers out there who are watching. In this particular fixfamilycourts.com, if you go there, and you see here a bunch of motions that you can file. Equal protection motion, due process motion, and I'm sure you agree, Barry, that a lot of these cases, there's, due process violations. And so here are a few motions that you can click on, that you can look at. There's Take Me to the Motion page. Any last other recommendations that you have for protective mothers who are watching this show?
I think as a practical matter that, when you want to make this about constitutional issues and it doesn't get listened to much, and I'm not saying it shouldn't be, but that's the way it is. I think focusing on some of the research that we talked about, focusing on the facts of the case, and particularly focusing on how the circumstances negatively impact children are the kinds of arguments that will be listened to more. And, I think another part of the problem is that, what mothers are going through is horrific, and they have every reason to be angry and emotional and all of that. And it says nothing about their parenting ability, but they don't get listened to. And if we want to make changes, I think protective mothers need to think about how they're perceived and to try to say things in ways that the court could listen and could change things. And, that's one of my objections to just focusing on corruption. If you go to a judge and say, well, this is done because of corruption, you're not going to get a very good listen. But if you, talk about, hey, we have new information, new research from the most credible possible sources that say we can do this better, and I hope you'll be open to listening to this information. It would be hard for a judge to say, no, I want to stay ignorant. So, we need to think about practicalities of the best way to get this to change, rather than our technical rights that too often aren't going to change the judge's decision?
Maybe it would be an idea, since we're running out of time. It's going to take time. Speaking of time, it's going to take time to get the Save Child Act passed. What I would love to see is one page on the Stop Abuse campaign website that has a bunch of motions listed that that the pro se mothers can use. I know, for example, that not allowing visitation, that is a criminal custodial interference. What can we do, when we're in that situation? We need one resource page with all the motions that we can file. Because right now we're just sharing this via Facebook and it's chaotic. So I'm hoping that the Stop Abuse campaign can do something like that for us and get all that information together on one page. That would be great. So that said, I want to end the interview here. I know there were a bunch of other questions that I have, but we only have so much time. I'm hoping that you can come on future shows and help particular protective moms in situations. And I want to also thank you for all the other activism that you're doing, such as the Freedom Riders bus tour that you recently held in New Jersey to try to stop tenure of this awful New Jersey judge. I can't remember his name, Eskandar or something like that. Eskandar. I think that's wonderful activism. We need more of that all around the country. So thank you for all you are doing with the Stop Abuse campaign and all your expertise, sharing your experience and expertise. And thank you for being on the show today. On behalf of all protective mothers and our children, I cannot thank you enough for supporting our human rights to be safe and protected. And we can only hope that more men and more attorneys follow in your footsteps. And for most of us that are watching right now and our children, it's too late. The damage has been done. But we can fight for others and for the next generation so they do not have to endure the suffering that we are experiencing. So thank you so much for being on and for everything you do.
Okay, you're welcome.
Thanks, Barry, and thank you all for watching another episode of Hell is for Children. I hope you'll tune in again next week. Have a wonderful weekend, everybody.